If something happened tomorrow, would the law protect the people that you actually consider family? Hi, I'm Laura Lee Thompson. I'm a litigation attorney at Melone Hatley, PC. Today I'm talking about estate planning for LGBT couples. Your partner, your children, your chosen family, they might seem obvious to you in your daily life, but without the right legal documentation in place, those relationships might not have the legal authorization or authority to do what you need in cases of emergencies or after death. That is where estate planning becomes so important because it allows you to define in writing who those relationships are and define what they can do after your death. One of the first problems that families face isn't about assets, it's actually about making decisions. If you're in a hospital and cannot speak, who has the authority to speak on your behalf? If bills need to be paid, who can step in and make those payments? Many assume that their partners can do this automatically, but that's not always the case. This is where documents like a medical power of attorney, durable power of attorney, or medical directive come in. These documents allow you to name a person that you trust to make these decisions instead of leaving it up to the law to decide who that default person would be. For LGBTQ families, that decision can be extremely important. You may have a long-term partner, children or stepchildren, chosen family, or close friends who play an important role in your life. Without a will or trust, estate law may decide who inherits your assets, and those outcomes may not match your intentions. So putting your wishes into writing is highly advisable. It helps ensure that the people that you care about are actually included. One of the most overlooked issues are beneficiaries. A lot of people spend time creating a will, but then don't spend the time to include beneficiaries. But those designations really do matter. In many cases, that could include who receives things like your life insurance, retirement accounts, investment accounts. If those designations are outdated, those assets might go to someone that you didn't intend for them to go to. This is especially important in changes in your life, like separation, or marriage, or changes in your family structure. So when children are involved, this can be especially important. Questions about guardianship, parent-children relationships, or financial planning need to be answered directly. So who would care about your children if something happened? Have those roles been legally documented? Is there a plan in place to manage assets for them? These are decisions that can shape your child's stability and future. So why marriage alone is not enough? Marriage does create important legal rights, but it doesn't cover necessarily everything. It does not update beneficiary designations automatically. It doesn't create a plan for children. It does not create trust protections. And it doesn't account for more complex family structures. Estate planning is what fills in those details. So bringing it all together, at its core, estate planning is making sure that your life is accounted for in those legal documents. Who you trust, who you want involved, and who you want to help make those legal decisions. For LGBTQ couples and families, that clarity does matter. Because without it, the law may fall back on assumptions that really don't match your family structure. So if you have not looked at your estate plan recently, or if you don't have one, this might come as an important first step. So estate planning really outlines who has the ability to speak for you, who gets access to your assets, and who will carry out your wishes. I'm Melone Hatley, PC. We work with individuals, couples, and families to create estate plans that can help address your estate planning needs. If you have questions about planning for your future or protecting the people that are in your life, feel free to reach out to one of our team members.